is filed along with the appeal seeking suspension of the sentence and from seeking bail. The counsel for the appellant, taking this court to the records, more particularly the complaint at exhibit P15, submit that it is the appellant who had set the criminal ball into motion by filing the complaint stating that deceased had last spoken to him at 9:30 p.m. on 14/6/2020 while she was watching TV at home. Thereafter, he retired to his room. That on 15/6/2020 at about 7:30 a.m. he left for his work at We Trust Roofing Sheet Solution. And when he returned, please take your seat. When he returned at 8:30 a.m. and called for his mother, there was no response. 9:05 a.m. Which arrived at 9:05 a.m. He thereafter shifted his mother and took his mother in the ambulance to Rajarajeshwari Hospital. The doctor refused to admit her due to COVID-19 pandemic. Consequently, in the very same ambulance, he took her to Matru Nursing Home at Kengeri, Upanagara, satellite town, where the doctor, after conducting ECG, had declared that she had suffered heart attack. Accordingly, he brought her mother back home, and upon the advice of the neighbors, as an abundant caution, he had approached the police seeking their intervention to conduct the post-mortem of her mother. Based on the said complaint, the case was registered. Counsel for the petitioner, appellant, submits that the trial court, without taking this appellant of the offence alleged, this is the compelling circumstances which warrants interference at the hands of this court, requiring suspension of sentence and granting bail to the appellant. Per contra, additional SPP, taking this court to the post-mortem report at exhibit P2, submit that the very cause of the death as reflected in the post-mortem report is asphyxia as a result of combined effect of smothering and throttling. He also points out to 7 external injuries found on the dead body of the deceased Meenakshi, besides the internal injuries. Thus, he submits the very post-mortem report providing the cause of death of the deceased with the external injuries found thereon had created the suspicion about the version narrated by the appellant in his complaint to the smart locking system provided to the house, additional SPP where the incident had taken place. He also takes this court, attention of this court, to a correspondence which was issued by Matru Hospital dated 18/8/2020, addressed to the Inspector of Police, Kubulgod Police Station, which reads that on 15/6/2020, there was no treatment of any nature whatsoever administered to said VG Meenakshi, and that there are no documents available in that regard. Referring to the said document, he submits that the very story created by the accused in the complaint of he having taken the deceased to the Rajeshwari hospital and thereafter to Mathu hospital is a concocted one, only to make it appear that the deceased had died of the heart attack. He also takes this quote to the inquest report, wherein the sister of the deceased, Pushpalata, had deposed that prior to, during the lifetime of said Meenakshi, the accused was physically assaulting her in an intoxicated state of mind, and that revealed the facts otherwise. Pertinently, the external injuries, 7 injuries which are sustained and found on the dead body, not being explained by the appellant, not being whispered by the appellant in the complaint, gives rise to bona fides of the complaint about he having given the complaint to the police as a matter of abundant caution at the advice of the neighbors. The material in the nature of communication issued by the Mathu hospital of they not having administered any treatment to the deceased would further belie the case of the appellant of he having taken the appellant and the doctors at the said nursing home having conducted ECG and thereafter informing the appellant about she having died of heart attack. Therefore, the circumstances, this court is of the considered view, matter requires consideration, reappreciation of the evidence, appellant not having made out any compelling circumstances warranting interference at this juncture, application is rejected.
Matter may be admitted.
No, it's not admitted. Paper books ready madake.
Madam.
Friday. You want time?
Apply time allows.
At request of
This matter may be connected along with Milord's yesterday I made submission filed by appeal number 1, which is pending Milord's, wherein records have been called for. And
connected matter ಏನಾಗಿದೆ?
ಅದು ಅಡ್ಮಿಟ್ ಆಗಿ ರೆಕಾರ್ಡ್ಸ್ ಕಾಲ್ ಫಾರ್ ಆಗಿದೆ. But IA is not yet decided, Milords.
Decide ಆಗಿಲ್ಲ.
Suspension is not.
It is ordered to be posted after 4 weeks, Milords. Last week ಬಂದಿತ್ತು ಅದು matter.
Accused number 1 and 3. Admit ಅಂತ ಮಾಡಬೇಕು.
Yes, admit. Call this matter along with.
It is submitted in the other case also. This
6/28 of 2025, Milords. 6/28 of 2025.
Call this matter along with so and so. Please stop.
Recovery is there, Milords.
It is the record.
Yes, that SVP to submit
Records.
that there is another connected matter arising out of the same order. It is in criminal appeal number so and so, wherein this court, after having admitted the appeal, has listed the matter for consideration of the application up to 4 weeks. Since the records are required to be this matter along with the said appeal.
Surname ಏನು ಸೇರಿಸ್ಕೊಂಡ್ರು? ನೀವು ಸೇರಿಸ್ಕೊಂಡ್ರಾ? Okay. So, you are from Ballari belt? The Rosi is a famous bear sanctuary. Yes. Okay. We have passed through that ಹೊಸಪೇಟೆಗೆ ಬರೋವಾಗ ಬಳ್ಳಾರಿಯಿಂದ ಹೊಸಪೇಟೆಗೆ ಬರೋವಾಗ.
Yes.
Not in all 19 witnesses, all have turned hostile, including the IO would support my version. This I have not clear case of not moral conviction, not case of prosecution. Not is this. Mother allegation is mother did not know that the daughter may not had failed in second PUC, 4 subjects in second PUC exam. Suddenly she would come to know in the fit of rage. Mother daughter had failed in 4 subjects is not supported by the prosecution. Daughter had failed in 4 subjects is not supported by the prosecution. Everybody says, everybody in the family knew that the daughter had failed, including the accused knew that daughter had failed in the examination. That is not a reason for her to commit murder of her own daughter. The IO admits that he did not collect CCTV of the surrounding houses or the road. IO admits that he did not send the knife to the FSL to show it whether that really had my fingerprints. But he has not done anything except not saying that the neighbor said the accused admitted that she is the one who committed the offense. Your Lordship will in fact not find, not 106, not I brought to the notice of the learned, so I'm not judge, that if you want to invoke 106 of Evidence Act to show that is house murder, the prosecution will have to first establish their case. But none of the witnesses have supported the case of the prosecution. Your Lordship will find, not from page 50 onwards, my lord. Page 50, not para 29. No, none judge may not would extract what is stated in the cross-examination of PW1, the complainant. Para 29, not first. Please, my lord.
What are the nature of injuries?
Not nature, very, so far as I am concerned, I have sustained 8 injuries. Daughter also I'm not a
Who lodged the complaint?
Not my husband's servant. Not my person who was working with my husband. My husband is no more.
What time was the incident?
Not incident, not somewhere, not in the evening. Discovered in the evening.
Discovered in the evening.
Discovered in the evening. Not after the incident, I also fall unconscious. But your Lordship will find, not my statement, not in 313, which is extracted at page 87. She is not aged lady. She was on bail throughout trial.
Thinking the scenario. Yes, you wanted to show 313.
Not 313, not page 87. Not 313, not page 87. Not my version. Page 87, para 97. ಆ ದಿನ ಕನ್ನಡ ಪೋರ್ಷನ್, ಆ ದಿನ ನಾನೇ ಮನೆಯ ಬಾಗಿಲು ತೆಗೆದೇ ಇತ್ತು. ನಾನು ನನ್ನ ಮಗಳಿಗೆ ಹಾಲು ಕೊಟ್ಟೆ. ಸ್ವಲ್ಪ ಸಮಯದ ನಂತರ ಯಾರೋ ಮನೆಗೆ ಬಂದ ಹಾಗೆ ಆಯಿತು. ನನ್ನ ಮಗಳು ಕೂಗಾಡಿದ ಶಬ್ದ ಕೇಳಿ ನಾನು ಅವರ ರೂಮ್ಗೆ ಹೋಗಿ ನೋಡಿದಾಗ ಯಾರೋ ಅವಳಿಗೆ ಹಲ್ಲೆ ಮಾಡಿದ್ದರು. ಒಬ್ಬ ವ್ಯಕ್ತಿ ನನ್ನ ಮುಂದೆ ಓಡಿ ಹೋದ. ನನಗೂ ಸಹ ಚಾಕುವಿನಿಂದ ಹಲ್ಲೆ ಮಾಡಿದ. ನಾನು ಪ್ರಜ್ಞೆ ತಪ್ಪಿದೆ. ಅನಂತರ ಚಾಸಾ ನಂಬರ್ 1ರವರೆಗೆ ಕರೆ ಮಾಡಿದೆ. ಇದೇ ವಿಷಯವನ್ನು ನಾನು ಚಾಸಾ ನಂಬರ್ 1ರವರೆಗೆ ಹೇಳಿದೆ. ಆದರೆ ಪೊಲೀಸರು ನನ್ನ ಮೇಲೆ ಸುಳ್ಳು ಕೇಸು ಹಾಕಿರುತ್ತಾರೆ. Not this version, whatever she has stated in her 313. Number 2, ID card was sent to FSL. Nothing, no blood stains found in the FSL. Not on the number 2, ID card was sent to FSL. Nothing, no blood stains found in the FSL. Not on the ID card.
No, but PM report shows strangulation.
PM report will strangulation and ide, but that's why this is seized from the same room after 1.5 months without any blood stains.
It was seized after 1.5 months.
1.5 months.
Was it then how she was connected to the crime?
only on the ground that as soon as the incident, you have informed PW1 that I have committed the offense.
Confession.
Confession.
PW1 has supported.
PW1 has supported, he doesn't
Confession.
he doesn't support the confession. No, that's why I read to your lordship. This is not what page number 50, what PW1 has said.
Then I think records are required also. Nodokke. Records nodidre gottagbidu.
Of course, not everybody has turned hostile.
No, you said confession. So the main link was the alleged confession.
That's why I brought your lordship. When notice page 50.
Records.
Yeah, why your IO has not collected the fingerprints from the spot?
Fingerprints illa, CCTV illa. Only on the basis of alleged.
CCTV was there in the house.
ಮನೆಯಲ್ಲಿ ಇರಲಿಲ್ಲ, ಹೊರಗಡೆ ಇತ್ತು.
313 defense.
But fingerprints first thing that the
313 defense goes against my lord's evidence of my lord's doctor PW6, before whom my lord's she has given history, my lord's with history of self-inflicted injuries.
I'm acquitted of 309.
Heavy, my lords.
I'm acquitted of 309.
But injuries were there,
of
my lords,
309.
and she herself has given
was
history.
produced by the police only.
No, my lords, at 8 p.m. on the same day, my lords.
Correct.
It was produced by the police.
See, when she was accompanied by the police,
I had to go through the LCR's, my lords,
see,
records.
whether she had given her.
Anyway, I'm acquitted of 309. If he acquits me of 309 of having caused injury on myself,
By the doctor, possibility or already possibility ಇದೆ. Records search ಮಾಡಬಹುದಲ್ಲ ಇದು?
Records may be confirmed, my lords. The matter may be admitted.
Admit ಮಾಡಿ. For consideration of I-105, records are required. Paper books, call for TCRs.
liberty to move vacation bench if they are required.
Vacation bench.
Vacation bench.
Paper book ಅಷ್ಟರಲ್ಲಿ ಬರುತ್ತೆ. ಎಲ್ಲಿ this is from which court?
Bangalore.
ಬೆಂಗಳೂರು.
Bangalore. But can I request a password? No,
ಕೊಡ್ತೀರಾ? You have 313.
I have everything with me. Please, 230.
Pass. Seal number 4, Ranganath Reddy R, SPP.
In this year was when she was around 58 years. Yes.
But the appellants herein, over the accused number 14 and 15 in the instant case, presently convicted for the offences punishable under section 302, 120B, 143, 147, 48, 114 and 149 of the Indian Penal Code. But the gist of the prosecution case is that, my lord, one Chinnaswamy, he was the propositor of certain landed properties. My lord. He had 2 wives, and the offsprings of both the wives, my lord, that is the half brothers, my lord, they were in a scuffle in connection to certain landed properties, which had in fact, my lord, led to 3 criminal cases, my lord, out of which 2 being cases punishable under section 302 of the Indian Penal Code, culminated out of, and in a fit of revenge, my lord, the accused number 1, and in a fit of revenge, my lord, the accused number 1, my lord, he contracts accused number 2, 3, 4, 5, 10, 11, and 17 to, my lord, exterminate the deceased. Now, in connection to the same, my lord, the limited role played by these appellants is that they were the informants, along with the 12, accused number 12, 13, and 14. These 5 accused persons were the informants, oh my lord, who had communicated regarding the whereabouts of the deceased to the accused persons, that is 2, 3, 4, 5, 10, 11, and 17, who, my lord, hatched the conspiracy to hack the deceased. Now, pursuant to the information issued by the accused number 12, 13, 14, 15, and 16, the other accused persons, my lord, they had assaulted the deceased with deadly weapons, allegedly assaulted the deceased, to which the deceased had succumbed. This is the allegation. Not in the judgment, my lord, rendered by the trial court. But what's ironical is that, my lord, there is not even a single averment, my lord, in the entire judgment as to why As to what the materials files. Nowhere these accused persons are files. Nowhere these accused persons are seen, my lord, anywhere near the scene of offence.
Error 85.
Of the judgment, my lord. Yes.
Read.
This is the extraction of a cross examination. Please, my lord. On scrutinization of the cross examination of the PW 33 conducted by the counsel for the accused number 1 to 5 and 9 to 12 and 14 to 16. The witness during the course of cross examination, the PW 33 also replied to the query put forth by the learned counsel for the accused number 11 and 16 that the informant had not came to the police station along with the CW 42, for which the court would like to extract the cross examination of PW 33 at page number 2. Line number 2 and 3, which reads as this: ಆ ಸಮಯದಲ್ಲಿ ದೂರದಾರರಿಗೆ ಠಾಣೆಗೆ ಚಾಸ 52 ರವರೊಂದಿಗೆ ಬಂದಿರೋದಿಲ್ಲ. Further, during the course of cross examination, witness also replied to the query put forth by the learned counsel for the accused number 11 and 16 that witness had transmitted the FIR to the jurisdiction magistrate in between 7:45 and 8 p.m. Further, during the cross examination of witnesses also replied to the query put forth by the learned counsel for the accused number 11 and 16 that witness had registered the FIR at about 7:35 p.m. Further, the learned counsel for the accused number 1, 9, 2, 14 and 15 have adopted the cross examination conducted by the learned counsel for the accused number 2 to 5 and 10. During the cross examination, that serial number 7 of the exhibit P56 came to the knowledge of the witness on the information provided by the CW54 on 28/8/2021 at about 6 p.m. Further, during the cross examination of witness also replied to the query put forth by the learned counsel for the accused number 2 to 5 and 10. The witness mentioned the accused name in exhibit P56 on the guise of the exhibit P1. Further, during the cross examination, witness also replied to the story. Put forth by the learned counsel for the accused number 2 to 5 and 10. CW and Bhairappa had not come to the police station, for which court would like to extract the cross examination of PW 33 at page number 7, line number 2 and 3, which reads as this: ಠಾಣೆಗೆ ದೂರುದಾರ ಭೈರಪ್ಪ ಬಂದಿರೋದಿಲ್ಲ. Further, during the cross examination of PW 33 also replied to the query put forth by the learned counsel for the accused number 2 to 5 and 10. Witness had filled up the column number 5 of the exhibit P56 on the guise of the exhibit P1 and further only on number 5 of the exhibit P56 on the guise of the exhibit P1 and further only on verification of the exhibit P1. Witness inserted the provisions of 120B of IPC. Further, during the cross examination, witness also replied to the query put forth by the learned counsel for the accused number 2 to 5 and 10 that as the case involves heinous and grave in nature on account of that, PW 33 had not conducted.
Gowda.
That is under
It
adjudication.
is still pending.
Under adjudication in the court of Tali, my lord.
These
This
witnesses
Tenkini court.
were the accused in that case.
Please, my lord. And in none of those cases, my lord, these appellants are connected to.
Now, in that, Channa Krishna and others, these accused were also accused in that case, in Obegowda's murder case.
No, my lord. Absolutely not, my lord. This is the first case, my lord. There in.
That sheet says that Obegowda was murdered by Channa Krishna and his people.
I mean, my lord, I'm limiting myself to these appellants, my lord. These two accused persons, my lord, 14 and 15, they are not
They
in
were
any
not
way connected to any other criminal case.
They were not family members. They were not implicated in those cases.
No, my lord. They're not the family members. In fact, their limited role, which is attributable against them, is they were the informants of the whereabouts of the deceased, my lord.
Shadowing.
In the instant case. My lord, the only place, my lord, they have not filed.
This,
My lord, the only place, my lord, where there is some mentioning, my lord, of these accused persons is that, my lord, at ink page 154, my lord, that is page 135 of the judgment, my lord. And apart from that, my lord, another juncture where these accused persons are, there is some mentioning regarding these accused persons is that, my lord, at ink page 171, my lord. 171.
They cannot rely on this confessional statement of one accused. All witnesses hostile ಆಗಿದ್ದಾರೆ ಅಂತ. Page number
171.
yes.
171, my lord, in the midst of the page, my lord, there's a reference to the self-statement of the accused number 12 to 14. Further, witness identifies the self-statement. Here, witness is the IO, my lord. The self-statement of the accused number 12 to 14, and also witness is the IO, my lord. The self-statement of the accused number 12 to 14, and also identifies the signatures found therein, and same is marked as.
Was recovered. See, only section 27. It's admissible only to the extent of 27.
Please, my lord, but it came to be marked, my lord. The plain statement has came to be marked.
The entire statement was marked.
Please, my lord.
Is that correct? Then that is wrong, no? And relying on that is also again wrong.
Yes,
Again, it's an error, my lord.
Only on voluntary statement of these accused, they are
Only on the basis of voluntary.
But I've got the order sheet as well.
Based only on the voluntary statement of co-accused.
This is the Shankar.
This is his sanction.
This is the Shankar.
He was also involved
This
in
is-
murder case.
This is the Shankar.
His name is Shankar.
Shankar.
And
He
he is related to
CW 1 and 11, my lord.
and CW1 apparently involved in the death of Channa Krishna,
Please, please, my lord, please.
which is what led to the.
Please, which is what led to this. The motive was the other person's murder of Channa Krishna.
And they're related.
They're brothers, my lord. The accused number 1 and Channa Krishna are the brothers, my lord.
Yes, sir. Present appeal is by case in CC number 2011. Murder of one. Murder of one. Death of one Shankar. Suspecting involvement of the accused persons on the ground of there being a family feud between the families of the accused and the complainant on account of certain property disputes. The case was registered for the aforesaid offences. The trial court, on examination of witnesses, examination of 37 witnesses and other evidences, convicted the accused persons for the offences alleged against them under the provisions of IPC referred to here and above. As for the appellants, taking this court to the reasoning and the documents enclosed, contain this confessional statement, there is no material of any nature whatsoever produced by the prosecution regarding any witness having seen them or any material indicating their role in the entire episode. He submits that the trial court has not adverted to this aspect of the matter. He refers to paragraph 90 of the impugned judgment and order to justify his statement as submission, except a gloss over reference in the said paragraph. There is no discussion of any nature whatsoever by the trial court, even while handing over the severe punishments that the accused 14 and 15 deserve to be granted interim relief of suspension of sentence and bail. Per contra, the counsel for the respondent on a query, the counsel, the SVP,
HCGP, my.
HCGP, clearly submit that there has been no incriminating evidence against accused number 14 and 15, except the confessional statement of accused number 4. Heard Perusa records. All the accused, all the witnesses have turned hostile. The only reason assigned by the trial court, as seen in para 90 of the impugned judgment, is that a portion of the self-statement of the accused apparently disclosing the involvement of accused number 12, 15, 13, 14, 16 being the acquaintance of accused number 4. Except this, there is no other reference in the impugned judgment regarding the role of the accused number 14 and 15 in the commission of the aforesaid offence. In that view of the matter, this court
All the materials, material witnesses have turned hostile, my lordship.
heading,
Official,
heading.
official witnesses have supported that.
Yes, all the
ಅಂತ ಹೇಳಿದ್ರಲ್ಲ ಹಾಗೆ
ಅದನ್ನ ಮೇಲೆ except the official witnesses made out of our submission, fairly submission, except the official witnesses, other witnesses have done mistake. Yes. In that view of the matter, this court will consider view the accused number 14 and 15 application filed under IA 1 of 25 by accused number 14 15 deserves to be considered in the affirmative. Accordingly, applications allowed, sentence suspended
against them.
against accused number 14 and 15. They shall be released on bail with the following conditions: that they shall execute bond for rupees 50,000 each, with like some surety, two sureties. They shall make
appear before the court
whenever required.
They have no other criminal interest.
Yes, it is also made reasoningly. It is also CP submit that there are no antecedents against the number 14 and 15.
Highly grateful.
Communicate the copy ಅದೆಲ್ಲ ಬರ್ಕೊಡಿ.
Seal number 5, Vijay Kumar R, Vasant Kumar N.
Appeal by the wife, my lord, in relation to a grant of decree of divorce. They lived for 36 days. In 2019, on 16/12/2019, according to my amendments in the petition for restitution, I filed restitution also, which has come to be dismissed, against which I filed an appeal, which is not yet appeared before the honorable court. Now, the husband filed for restitution of conjugal rights. During the relevant period of time, COVID was in place. Therefore, I could not go and meet him. After 2019, in 16/12/2019, according to me, he dropped me in my brother's place. My parents are no more. And therefore, he did not take me back. Therefore, I filed a police complaint in February 2020. Then he gave a reply to that. He gave a statement. Serious allegations are made.
This is a first appeal. We have to hear you on merits.
Yes, ma'am.
Till then, the matter has to be stayed. Decree has to be stayed.
No,
Till the records are received and
Yes, that could be.
the thing is, my lords, in the trial court, though she filed a restitution petition, she was continuously absent, and the matter was dragged for one or the other. And moreover, this is a non-consummation of marriage, and she's married. and she's married and lived with only for 35 days. And beyond which, she went to police station to claim her things. In the police station, she...
See, we have to read,
Yes, ma'am.
reappreciate the evidence. This
Yes,
is
ma'am.
first appeal.
Yes.
We'll admit, call for records
Admit.
and grant a stay.
Madam Told.
Soon after the records come, we can argue the matter.
Yes.
Admits. Stay as paid for. Call for records. List on.
Grateful,
18-6.
grateful.
List number 1 for admission. Seal number 19, Nishit Kumar Shetty.
For the appellant, my lord.
Speaking.
Appellant is accused number 4, my lord, for the offence under section 143 witness, my lord. They turned hostile to the case of the prosecution, my lord. The trial court, my lord, only on the basis of, my lord, the evidence of the family members of the deceased, my lord, that they stated about there is some motive is there, my lord. Only on that basis conviction is granted by the trial court, my lord. The petitioner is on bail during the course of the trial. In fact, my lord, this petitioner is granted bail, my lord, after the examination of the witness, my lord, this and though it is not relevant, my lord, well, it is a direct witness, my lord, witness turned hostile to the case of the prosecution, my lord. And there is no recovery from the petitioner. The allegation is there is no attack against the petitioner. The only allegation in the charge sheet is that petitioner was present at the time of the incident, my lord. The petitioner was granted bail by this court, my lord, after examination of the material witness, my lord. There is no recovery also. And all the recovery witnesses also against the accused, other accused persons also turned hostile to the case of the prosecution. Observation of the trial court, my lord, I have not cross-examined some of the witness, my lord. Some of the witnesses with that, my lord, it is not relevant because they are turned hostile to the case of the prosecution. PW2, PW3, PW10 are the witness, they turned hostile to the case of the prosecution. In fact, PW2, my lord, he in the chief examination stated something about the other accused person, not to the petitioner, not to the appellant, my lord. When there is a direct evidence, my lord, the family members of DCC stating that there is some motive, my lord, they are identifying the appellant, my lord. On that basis, the conviction was granted, my lord.
What was the motive?
Motive was saying, my lord, accused number 1, petitioner is accused number 4, my lord. Accused number 1, brother and the father of the deceased, they are known to each other and they are used to having drink together, my lord. He was died because of the fits, and accused number was thinks that, my lord, the father of the and accused number was thinks that, my lord, the father of the deceased was the reason for his death. That is a very weak motive, my lord.
With him.
She was stating that PW2 informed that petitioner appellant was present in the spot.
Correct. Is it their case that they conspired accused number at the instigation of accused number 1?
That is not there. That is not there.
Now, then why?
Nothing is mentioned like that.
Nothing is mentioned like that.
Even
Then
according to the charge sheet copy, huh?
PW2 was informed that the complainant, that is mother of the deceased, saying that the appellant was present along with the other accused person and they assaulted the deceased. On that basis, she was lodged the complaint and the complaint was registered.
All the accused are the residents of the same locality.
Same locality.
Same locality.
She knows everybody.
Correct. A1 had the motive against the deceased. How A4 was included or brought into
A4 is the relative of the accused number 1.
relative of
Relative of the accused number 1.
the same position continues. Then trial court relied on what?
Trial court, my lord, relied on the evidence of the PW1 and all the deceased members, my lord, who said about motive.
Motive. Only regarding
Motive.
Their evidence was
Nothing was on record.
They do not
Even
speak
the
about-
Caesar Mazar witness also turned hostile to the case of the prosecution. All Caesar Mazar, except the official witnesses, all Caesar Mazar witness, though there is no recovery from the appellant is concerned.
Those relatives who suffer, these people were hearsay. They say that his PWP informed them, but they themselves are not supported. And these are not eyewitnesses. They speak only from the basis with the hearsay. Because they are relative of accused number 1. Whether he has any other criminal antecedent?
No,
No,
madam.
no, my lord.
I verified.
No, my lord.
Age 25.
Okay.
This appeal is by
His wife is also 38 weeks pregnant, my lord.
in SC number
Wife is pregnant.
122, being agreed with the judgment and order of sentence at 9/4/2025 passed on the file of 63rd Additional City Civil and Session Judge, by which the appellant along with the other accused have been convicted of the offences punishable under section 143, 143, 144, 147, 48, 149 of IPC, and section 25 bracket 1B, close the bracket, and 27 of Arms Act. And accused number 3, by taking machu from accused number 2, had assaulted the deceased on the head, and accused number 5 had collected machu from accused number 3 and had hit him on the head, and the said incident had been witnessed by one Pratap, who was examined as PW2, and his friend one Surya, examined as CW3. Good start. The motive for commission of the aforesaid offence is stated to be death of one Velu alla?
Rajavel.
Karunani.
G Velu is the father of the.
Rajavelu na? G Velu.
Oh, G Velu.
Sattogiddu.
G Velu, my lord.
Death of one G Velu, father of the deceased and brother of accused number 1, father of the deceased, which was attributed to the brother of the deceased.
No, my lord. The Rajavelu, the father of the
cause of incident,
father of the deceased and the brother of the accused number 1, they are friends, and they are suspecting that he is the responsible for the death of.
Father of accused number 1 was the friend of
Friend
father
of
of this
Yes,
deceased.
Raju Velu.
Page number 21, my lord, para 10 of the impugned order, my last para.
Said G Velu and Rajavelu had gone to Sudhamanagar, where Rajavelu had suffered from fits and was taken to the hospital, where he died. The brother of Rajavelu suspected G Velu to be the reason for the death of their brother Rajavelu. This suspicion grown into enmity, which resulted in G Velu being threatened by the accused person.
Accused person.
Counsel for the appellant, apart from taking this court through the grounds urged in the memorandum of appeal, also furnishes a copy of order 26/6/2024 in criminal petition number 5463 of 2024 under section 439 of CRPC, and submits that the accused appellant herein had been granted bail after recording of the evidence.
Material witnesses. Material eyewitnesses.
Material eyewitnesses, in which CW2 to CW5 had turned hostile.
Hostile.
So also,
In
Well,
these scenarios, they
yes.
were relatives, those who supported, they were not eyewitnesses.
and the other witnesses were the relatives
Relatives of the deceased.
of the deceased had not supported the case of
No,
the
no,
They supported the case of
They
the
were hearsay witnesses.
hearsay witnesses.
The said witnesses were merely hearsay witnesses.
Witnesses.
So he submits, and when the eyewitnesses had turned hostile,
Turn was complete turn hostility.
which factor had been taken into consideration by this court while granting
Granting bail.
He was not the actual assailant. Assailants were 2, 3 and 6.
by this court while granting the bail, and when the role of the pleasant appellant does not indicate any overtact,
Or tax man.
comma,
And no recovery.
and
No
there
recovery.
being no recovery by the investigation, comma, he submits the present application seeking suspension of sentence and granting of bail requires to be considered the affirmative. Per contra, Sri HCGP
She concedes that these witnesses have turned hostile.
concedes that PW 2, 3, 10, who are the eyewitnesses, have not supported the case of the prosecution. However, she submits that PW 1 and 9, 1, 4 and 9,
PW1 and PW 4 to 9.
4 to 9, where the relatives have indeed supported the case of the prosecution. Hence seeks for rejection of the application. Heard Perusa records. The case of the prosecution is that the accused persons, including the appellant herein, were present near the place of incident and were seen by PW 2, 3 and 10. However, even the said witnesses have turned hostile and have not supported the case of prosecution. In the absence of any, besides, in the absence of any recovery traceable to the information given by the appellant herein, and in the absence of any specific allegation of overtact against the appellant of any actual assault, also in the light of this court having taken to this aspect of the matter, having granted the bail, we ordered it at 26/6/2024, this court is of the considered view that the appellant in this present appeal deserves to be granted bail. Accordingly, the following order: IA1 of 2025 is allowed. Appellant is
Order of sentence is suspended against.
Order of sentence is suspended against the appellant in this appeal. He is released on bail on he executing bond for rupees 50,000.
Other two conditions.
Same conditions.
Matter may be admitted.
Admit.
Matter may be admitted.
And call for records.
Call for records.
Admit for complaint. They admit to paper in 8 weeks. All parties are selected. Yes, we'll take up the other matters in option. Other matters in the afternoon.
Serial number 20, my lord, after vacation.
My learned friend has given some proposal. I put my
23.
word.
Motor
20
accident.
Yes, ma'am.
Owner's
23.
23. Owner's liability.
That owner, no, my lord, it is owner's liability that I have challenged, that there is no insurance. That the my learned friend has given some liability that I have challenged, that there is no insurance. That the my learned friend has given some proposal. My clients have also come. I will expose.
Both counsels seek 23. Both counsels seek adjournment to explore the possibility of settlement. 4 weeks.
Please, after first week of the
Yadram date.
5th or
5/6.
5/6. Obliged.
Yes.
Serial number 20, my lord.
And serial number
20, my lord.
It's adjourned to 17/6.
20 is already adjourned.
17.
ಇಷ್ಟೊತ್ತಿಗೆ 138ಗೆ ಏನು ವಾಟ್ ಇಸ್ ದ ಅರ್ಜೆನ್ಸಿ You have suffered the decree? Yeah. Owner of the vehicle. No. Monday calls.
Serial number 43.
Hmm.
Release of a deposited amount need to be
43,
made.
no?
Yes. 1, 2.
Probably will not be able to take a final hearing with the other side ಯಾರು ರಮೇಶ್ ಕುಲ್ಕರ್
ದಟ್ ಅದಲ್ಲಿ
43 ಅಂದ್ರಲ್ಲ
43 ಎರಡು ಮ್ಯಾಟ್ರ್ ಅದಲ್ಲಿ ಎರಡು ಅಪ್ಲಿಕೇಶನ್ ಒನ್ ಇಸ್ ಕನ್ಸಿಡರೇಷನ್ ಆಫ್ ವಿಸಿಟೇಷನ್ ರೈಟ್ ದಟ್ ಇಸ್ ಕಂಟಿನ್ಯೂಯೇಷನ್ ಟು ಬಿ that was not done for the last 2 months.
Your lordship can fix dates, my lord. Earlier, my lord, your lordship had fixed 2 dates. She has been able to visit the child and spend a day. Further dates may be fixed. Third,
3-6
ಅಲ್ಲಲ್ಲ ನೆಕ್ಸ್ಟ್ ಅಂದ್ರೆ 2:30 ಇರ್ಲಿ ಹಂಗಾದ್ರೆ.
ಮತ್ತೆ ನೀವು ಎದಕ್ಕೆ ಮೆನ್ಷನ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
ಇಲ್ಲ ಅವ್ರೇನು ಅರ್ಜೆನ್ಸಿ ಇದೆ ಅಂತ ಹೇಳಿದ್ರು, ಅದಕ್ಕೆ ನಾನು ಕೇಳಿದೆ.
ಅಲ್ಲ ಅವ್ರ ಅದಕ್ಕೆ ಏನ್ ಹೇಳಿದ್ರು 3-6 ಫಿಕ್ಸ್ ಮಾಡಿ, ಆಫ್ಟರ್ ವೆಕೇಶನ್ ಫಿಕ್ಸ್ ಮಾಡಿ ಅಂತ ಹೇಳಿದ್ರು, ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡ್ತಾ ಇದ್ರು.
ಆಫ್ಟರ್ ವೆಕೇಶನ್ ಅಲ್ಲ,
ಆಫ್ಟರ್ ವೆಕೇಶನ್ ಫಿಕ್ಸ್ ಮಾಡಿ ಅಂತ ಹೇಳಿದ್ರು, ಡೇಟ್ ಫಿಕ್ಸ್ ಮಾಡ್ತಾ ಇದ್ರು.
ಆಫ್ಟರ್ ವೆಕೇಶನ್ ಅಲ್ಲ ಅಂದ್ರೆ 2:30ಗೆ ಬೇಕು.
2 and 9/5 that both the dates.
Because of this vacation child visitation should not.
But why did you mention it then?
Because he has mentioned, that is why I mentioned. ಎಲ್ಲರಿಗೂ ಇರ್ತೇನೆ ನಾನು 2:30ಗೆ ನೀವಿಲ್ಲ ಅಂತ ಹೇಳಿದಕ್ಕೆ ನಾನು ಹೇಳಿದೆ.
ನೀವೇ ತಗೊಂಡು ಕೊಡ್ತೀರಾ? ಸಬ್ಜೆಕ್ಟ್ ಟು ಕಂಪ್ಲೇಂಟ್ಸ್ ಕೊಟ್ಬಿಡಿ.
ಫೋನ್ ಮಾಡಿದ್ರಾ ಮೇಡಮ್?
ಬಂತು ಮೇಡಮ್. ಇದು ಚಾರ್ಜ್ ಶೀಟ್ ಕಾಪಿ ಅದು 918 ಅಲ್ಲಿ ದಪ್ಪ ಇದೆ. ಅದ್ರೊಳಗೆ ಏನಾದ್ರು ಹೇಳಿದ್ರ ಇದ್ರೊಳಗಡೆ ಯಾರು ನೋಡ್ಕೊಂಡು ಒಂದು ಚಾರ್ಜ್ ಶೀಟ್ ಕಾಪಿ ಕೊಟ್ಟಿಲ್ಲ?
ರಸ್ಸು
ಅಲ್ಲೇ ಕೊಡಿ. ಕೂಟಲ್ ಇಲ್ಲ ಏನು ಹೇಳ್ತಾರೆ, ಯಾರಿಗೋ ಪ್ರಾವಿಷನ್ ಗೊತ್ತಿಲ್ಲ. ಅದೇ ಹೇಳಿ. ಮೇಡಮ್ ಬೇರೆ ಮಧ್ಯೆ ಡಿಸ್ಟರ್ಬ್ ಮಾಡ್ತಾರೆ, ಅದೆಲ್ಲ ಅವ್ರ ಮಾತು ಇವ್ರ ಮಾತು ಅದು ನಮ್ಮ ಕೋರ್ಟಲ್ಲಿ ವರ್ಕ್ ಆಗಲ್ಲ. ನಮಗೆ 2 ಆಗೋಯ್ತು. ನಮಗೆ 2 ಆಗೋಯ್ತಲ್ಲ. ಮೂರು ದಿನ ರಾಘವೇಂದ್ರ ಸ್ವಾಮಿ ಸೇವೆ ಮಾಡ್ಕೊಂಡ್ಬರೋಣ ಪ್ಲಾನ್ ಮಾಡಿದ್ವಿ. ಈಗ 2:30ಗೆ ಪ್ಲಾನ್. ಅಷ್ಟೊತ್ತಿಗೆ ಮಾಡ್ಬಿಡಿ ಹೋಗಿ. ಸಾಧ್ಯನೇ ಇಲ್ಲ ಮೇಡಮ್, ಎಲ್ಲ ಲೆಂತಿ ಇದೆ. ಅಲ್ಲ ಎಲ್ಲ ಬೇಡ, 2 ಮಾತ್ರ ಹೋಗಿ. ನೀವು ಬೇರೆ ಯಾರಾದ್ರೂ ಬರೋದಕ್ಕೆ ಹೇಳುತ್ತಾನೆ. ಮಾಲನ ಹೆಂಗ್ ಮಾತಾಡ್ತಾರೆ ಹೇಳಿ. ಆಗಲ್ಲ ಹಿಂಗೆ ಉತ್ತರ ರಜಾ ಹಾಕಿದೀವಿ ಅಂತ ನಿನ್ನೆ ಬೇರೆ ರಜಾ ಹಾಕಿದೀವಿ. ಅವ್ರಿಗೆ ಎಷ್ಟು ಸಲ ಅವ್ರ ಟರ್ಮಿದಾಗ ನಮ್ಗೆ ಕೇಸ್ ಬಂದಿದ್ದು ನೋಡಿ ನಾವು ಮಾಡ್ಕೊಂಡಿದ್ವಿ. ರಾಘವೇಂದ್ರ ಸ್ವಾಮಿ ಕೇಳ್ಕೊಳ್ಳಿ, ಏನಾದ್ರು ದಾರಿ ಸಿಗುತ್ತೆ. ಬೇಗ ಬೇಗ ಮಾಡಿ ಹೋಗಿದೆ ಅವರು ಮಧ್ಯಾಹ್ನ ರಜಾ ಅದೇನೋ 3 ದಿನ ಸೇವೆ ಅಂತ 3 ದಿನ ರಜಾ ಹಾಕೊಟ್ಟಿದ್ರು ನಾಳೆ ನಾಡಿದ್ದು 2:30 ಹೊರಡ್ಬೇಕಂತೆ ಮಧ್ಯಾಹ್ನ ರಜಾ ಕೊಟ್ಟಿದ್ದಾರೆ ಈಗ ರಜಾ ಇವಾಗ ಸಸ್ಪೆನ್ಷನ್ 2 ಅಲೋ ಆಗೋಯ್ತು ಕೇಸ್ ಹಾಕ್ತಾರೆ ಇದು ಕೇಸ್ ಆಗಿ ಕಣಪ್ಪ ಇಶ್ಯೂ ಇಲ್ಲಿದೆ ಎಲ್ಲ ಫಸ್ಟ್ ಹಾಕ್ಬಿಟ್ಟಿದೆ
ನಂಗೆ ಪ್ರತಿ ವರ್ಷನೂ ಅವನು ಹೇಳಿದ್ದೆ ಕೇಳ್ಬೇಕು ನಾವು ಪಾಸವರ್ ಇರ್ತವಲ್ಲ
ರಜಾ ಬೆಳಗ್ಗೆ ಹೇಳ್ತಾ ಇದ್ದೀನಿ
ಅದು ಮೇಡಮ್ ಕೇಸ್ ಆರ್ದು ಯಾವ್ದು ಮೇಡಮ್
ಇಷ್ಟು
PS ಹೇಳ್ತೀನಿ ಅದಕ್ಕೆ ಹೋಗ್ತೀನಿ PS ಹೇಳ್ತೀನಿ ಅದಕ್ಕೆ ಹೋಗ್ತೀನಿ PS ಆಗ್ತಾ ರಜೆ ಇದೆ ಮೇಡಮ್ ಕೇಸ್ ಆರ್ದ
ಅವ್ರು 2ನೇ ತಾರೀಕು ರಜೆನಾ
ಯಾರು
ಶ್ರೀಧರ
2ನೇ ತಾರೀಕು ನಮ್ದು ಫುಲ್ ಡೇ ಅಲ್ಲ ನಮ್ದು ಫುಲ್ ಡೇ
ಅವ್ರು ಬರ್ತಾರಲ್ಲ
ಎಲ್ಲ
ನಾನು ಬರಲ್ವಲ್ಲ ಹಾಕ್ಬಿಟ್ಟೆ ರಜಾ
ನೀವು ರಜೆನಾ ಫೋನ್ ಮಾಡ್ಕೊಂಡು
ಹಂಗೆ ಕೊಡು ಹಂಗೆ ಕೊಡು ಕವರ್ ಇದೆಯಲ್ಲ ಇನ್ನೊಂದು ಪ್ಲೇಟ್ ವೇಸ್ಟ್ ಆಗುತ್ತೆ.